It's my privilege to be here to speak to you today. She asked me to come and talk to you about Feet of Trust. And we had a discussion about what to call this presentation. It's called It's Not a Done Deal. I was talking to Robert Starks at the door before the conference started. And based on the issues up here, I thought, well, I might not have much to talk about when it comes to Feet of Trust. How would I know what Feet of Trust is? What do I know about Feet of Trust, and who am I, by the way? I was born in Sacramento, California. My folks lived in Plymouth when I was born. I grew up there. I served 10 years in the United States Air Force. I was what was called an equipment calibration and repair technician. After 10 years, I went to work for the world's premier semiconductor manufacturer, Intel, and I spent the next 23 years working for Intel Corporation. I learned a little bit about process when you work for Intel. It's all about process. There's nothing else to learn about process. It's fundamental to the manufacturing of semiconductors. You miss one step and millions of dollars have just gone down the drain. So I knew a little bit about process when the Ion Band of Miwoks came to Plymouth in 2003 and informed our community that they were going to take 208 acres into trust and build a casino. Oh yeah, and by the way, there's not anything that you can do about it. It's a done deal. And we're breaking ground in 6 months. That was in April. It is now 12 years later. Not one shovelful of dirt has been turned. We learned in those 12 years there is much that can be done. First of all, the Ion Band has in the words of the DOI, a unique history. Well, it is unique. Every tribe has a unique history. They were going to do what's called a two-part determination in 2003 when our governor was Gray Davis. Now, Gray Davis would give the tribes whatever they wanted. He negotiated the first 58 compacts with tribes in secret. Well, Gray Davis was recalled in 2005. And they decided that Governor Schwarzenegger probably wouldn't sign off on what's called a two-part determination, a feat of trust where the governor of the state has to agree, where the governor of the state can simply say no, and it's not a done deal. Well, they immediately became a restored tribe. Well, what is a restored tribe? If you look at the Indian Gaming Regulatory Act, 2719, commonly called Section 20, there are exceptions for tribes to be approved for gaming and for their land to be approved for gaming in that section. One of the exceptions is two-part. Another of the exceptions is if you're a Section 83 tribe, an initial reservation, if you have a land claim settlement, and the last one is restored. Well, what does restored mean anyway? Well, in 2003 or 4 or 5 or 6 or 7 or 8 or 9, you wouldn't find a definition of restored tribe. They just made up what a restored tribe was. They needed a lands opinion. They needed someone at BIA, NIGC, the National Indian Gaming Commission, to restore them, to write an opinion that they would qualify as a restored tribe. There was an associate solicitor there. His name was Carl Artman. He eventually became the Assistant Secretary of Indian Affairs. Well, Mr. Artman, in September of 2006, delivered a restored lands opinion for the Ion Band. Much to our surprise, the Ion Band had been recognized in 1972, terminated, and restored by Ada Deer in 1994. with a memo. Literally with a memo. March 22nd, 1994, Ada Deer issues a memo and the ion ban is restored. Well, Mr. Hartman included in this particular lands opinion a reference to a court case. And in this court case, he alleges, well, he lies, that this court case terminated the ion ban. Well, if you actually look at the history of the ion ban, you'll find that in 1979, they were left off of the first list of entities eligible to receive benefits from the government as an Indian tribe. They were put on the list of groups who were eligible to apply to become an Indian tribe, Section 83. They attended a workshop on how to complete the Section 83 process. And then they spent the next 10 years gathering the documents, the data, the information that was required under Section 83. For some reason in 1989, they informed the federal government they had their application complete and they were about to file it. But in 1990, they filed a lawsuit in federal district court. And in that lawsuit, they demanded that the federal government, the BIA, the Department of Interior, put them on the recognized list. Well, the Department of Interior, as you might guess, just rolled over and put them on the list. No, they didn't. The Department of Interior in 1990 defended the fact that the ion ban had never been recognized. They filed a motion, the feds did, for summary judgment based on the fact that the ion ban could produce nothing that indicated they had ever been recognized by any of the means available to Indian tribes, by treaty, by act of Congress, or by completing the Section 83 process. Federal District Judge Larry Carlton issued an order in 1992 so stating and granted the Department of Interior motion for summary judgment. They weren't terminated in 1992. They'd never been recognized. You see, they needed to manufacture a restored tribe. They needed to create a restored tribe where no tribe had ever existed. This case went on for another 4 years. The last 4 years of the case was involved in whether the county, Amador County, where we live, had any jurisdiction over the 40 acres that the Indians who lived at Ion had acquired quiet title to in 1972. Well, the federal court finally decided that, guess what? Amador County did have jurisdiction over that 40 acres. But much to our surprise, in the restored lands opinion, Mr. Hartman also claims they're landless. They're landless and restored. They own 40 acres, but they're landless. They never once stated in an application. The restored lands opinion, their DEIS or the FEIS, never once is it stated that the Ion Band owns 40 acres. In all of those documents, repeatedly, they were the landless, restored Ion Band. They're not landless and they're not restored. This was brought to the attention of all of the agencies multiple times by multiple people, including our group, No Casino in Plymouth. It doesn't matter. It doesn't matter. They don't care. They have an agenda. The Indian Gaming Regulatory Act, which Elaine mentioned, it talks about, you'll hear a lot about, off-reservation gaming. Section 20. There's another lady that, and she's just so near and dear to my heart. She worked at NIGC. She wrote lands opinions. She wrote a lands opinion for the Red Lake Band. It's the second lands opinion that was ever written. It's on the NIGC website. Go to the reading room, go to lands opinion. Look up Red Lake. They're in alphabetical order. You can put them in chronological order if you want. In this opinion, she writes at the very end. This opinion, by the way, is about a page and a third long. You can read it in 10 minutes. She writes that Section 20, that would be 25 U.S.C. 2719, is the section of IGRA that relates to off-reservation gaming. The words off-reservation do not appear in Section 20, nor do those words appear anywhere else in the Indian Gaming Regulatory Act. There is no such thing in the Indian Gaming Regulatory Act as off-reservation gaming. It is a creation of the NIGC, the Solicitor's Office, and the Department of the Interior. You might be surprised to learn that the very first lands opinion on the website was written for a tribe here, the Blackfeet tribe. It's a longer opinion. For whatever reason, your Attorney General here, and this opinion was written in 1990, I believe. Whoever your Attorney General then, he had read the Indian Gaming Regulatory Act, and he had looked at the definition for Indian tribes. He had looked at the definition for Indian land that would be eligible for gaming pursuant to the Act. If you read that, it's pretty straightforward. It basically says two things. Lands are eligible if they're within the limits of a reservation and held in trust. And is a conjunctive word, by the way. Now the NIGC, you'll find in that Red Lake opinion, that was hard for the General Counsel at NIGC to understand. It wasn't clear what that meant. So the NIGC took it upon themselves when they wrote their regulations. They rewrote that particular section. They changed some of the wording around, but they rewrote the regulations so that it says that Indian lands are eligible for gaming if they're within the boundaries of a reservation or held in trust. Or an and. Does anybody here think those two things mean this? Those two words mean the same thing? Is there a single person in this room that thinks and or mean the same thing? Well, in a face-to-face meeting with this particular General Counsel, this was brought to her attention. And her very words to me, she looked me right in the eye and said, Mr. Cranford, you don't understand. And or mean the same thing. Only in Washington, D.C., only at the National Indian Gaming Commission, only at BIA, only at BIA, do and or mean the same thing. They will do anything. They will do whatever it takes. I would encourage you to read the lands opinion for the Blackfeet tribe. It gets even better. Somebody had written and wanted to know that if fee land owned by a non-Indian within the boundaries of a reservation was eligible for gaming. So So what do you think the answer to that question was?
Sure.
Fee land owned by a non-Indian. Well, do you think it should be eligible for Indian gaming? No. Well, it's a good thing then that you can't work at BIA, DOI, or the NIGC. Because in Montana, according to the opinion that was written in 1990, fee land owned by a non-Indian within the boundaries of the reservation is eligible for gaming. These are the opinions that you get from a department and agencies within that department that have an agenda. They will do whatever it takes. More than 20 years after the Indian Gaming Regulatory Act was passed, they suddenly decided, based on the number of lawsuits they were encountering, that they needed some regulations. They had been operating for more than 20 years without any regulations. So they wrote what's called Part 292. And they defined, restored, you can look at the regulations. Well, one of the unique parts of this regulations they wrote was at the very end, they included a little section that said, oh yeah, any lands opinions that have already been written that don't comply with these regulations, they're okay. They're not affected by these regulations.
Wow.
Now, I can only find one opinion that that particular portion of the regulation would have anything to do with, and that was the ion ban, restored lands opinion. And that was written by Associate Solicitor Carl Artman. By the time the 292 regulations came along, he was the Assistant Secretary. Guess who got to sign off on those regulations? Mr. Artman. So he very conveniently included this little portion of the regulation that protected his own lands opinion. In 2008, by 2008, we had already filed suit in federal court. The state of California filed suit in federal court, and Amador County filed suit in federal court, challenging Mr. Artman's 2006 lands opinion. The federal court didn't hear any of the facts, didn't hear any of the merits. They simply said that you can't challenge this opinion because it's not a final decision. In 2008, No Casino in Plymouth sent a detailed letter to Solicitor David Bernhardt and other officials in Washington, D.C. And in that letter, we described what was wrong with the Artman restored lands opinion. We asked for a couple of other opinions. If in fact our request to have the ion ban's restored lands opinion withdrawn was, if they agreed to withdraw the opinion, we had no need of the opinions we had requested. In January of 2009, Solicitor David Bernhardt withdrew the ion ban's restored lands opinion because it was wrong. Those are his words, not mine. In 2011, Solicitor Hillary Tompkins, at the request of the ion ban and the National Indian Gaming Commission, reinstated Solicitor Bernhardt's opinion. Not based on the merits, not based on the facts, based on the fact that Solicitor Bernhardt, as a presidential nominated, Senate confirmed solicitor, did not have the authority to withdraw the land's opinion of an associate solicitor. Hogwash. They will do whatever they need to do. You will not find the ion band restored land's opinion on the NIGC website today. It took us an additional 6 months to actually have, after Solicitor Bernhardt said it was wrong, to actually have it removed from the website. It's not there today. This process for fee to trust, it requires application. They have to comply with environmental law. You will eventually see a public notice for a draft environmental impact statement. Here's all the things that our casino will impact your community with, and here's how we plan to mitigate it. Again, this draft environmental impact statement was for the landless restored ion ban. Dozens of times this phrase is repeated in that document. Every time it's there, it's false. Every time it's there, it's a lie. We commented on the DEIS. One of the most important aspects, from my perspective, with regard to this project was one of the requirements is that a DEIS contain a detailed project description. That should be right in the beginning. To this day, we do not have a detailed project description for this large Las Vegas style casino hotel that they plan to build in our community of 900 residents. Doesn't matter, they don't need a project description. How do you do a draft environmental impact statement if you don't have a detailed project description? You just make it up. The area where we live is in the foothills. And a lot of people think in California that there's this giant pool of water underneath the state. Well, I have news for you folks, there isn't. There is in the Central Valley, but there isn't once you get into the foothills. It's all fractured granite. And unless you hit one of those fractures, there's no water. They drilled a number of wells on the property that they don't own. They finally found 2 wells on their property that produced water. One produced 10 gallons a minute, and the other produced 35 gallons a minute. They found a neighboring property owner who had a well that produced 38 gallons a minute. And he said, yeah, you can use that well for your project. You can do the math if you have a calculator. This project required 119,500 gallons of water a day. And these 3 wells are going to produce that water. The long-term yield for these wells was 10 gallons per minute, 35 gallons per minute, and 38 gallons per minute. And they were going to pump these wells in rotation, according to the DEIS. You have to pump these 3 wells 7 days a week, 24 hours a day, together to produce 119,000 gallons of water. This was brought to the attention of the BIA, who was handling this environmental impact statement for the tribe. We requested a pumping schedule. The well data that was included in this particular EIS, none of these wells were ever pumped at 83 gallons a minute, not one. And there was also all the pumping times and recovery times. So we just asked for a pumping schedule. It wasn't included. They're just going to pump them in rotation. When the FEIS was finally issued, they had reduced the water required to 116,000 gallons per day. And the well production had been reduced from 83 gallons per minute to 81 gallons per minute, which just happens to produce 116,000 gallons per day. If you pump 81 gallons per minute, 7 days a week, 24 hours a day. No pumping schedule. There's not enough water available on this property to support this project. It's clear beyond doubt that this project, as proposed, should be rejected and declined, out of hand. Not with the BIA, not with the DOI. Did I mention that the Ion Band doesn't own any of this property?
Yes.
12 parcels. That's what's in the Fee to Trust application. Part of this process is you have scoping sessions. We had 2 scoping sessions. It was never explained to us why we had 2 scoping sessions. Nonetheless, we had 2 for 10 parcels totaling 208 acres. The application was for 12 parcels, 228 acres. They just added 2 parcels. No scoping on those 2 parcels. No, nothing. In fact, we didn't even know they'd added the 2 parcels until they issued the application. Nearly 3 years after the scoping session. As part of the process, they have to notice the DEIS. We're issuing a draft environmental impact statement, and the public is welcome to comment. And in that particular notice, it's on the Federal Register today, the Ion Band owns the 28 acres in fee. It's in the notice. Well, we immediately contacted the officials at BIA DOI and actually sent them documents from the Amador County Recorder's Office indicating that the Ion Band owned none of the parcels and requested that the Federal Register notice be renoticed with the truth in it. Well, we were finally notified that we're not going to do that. Federal Register notice exists today with a lie in it, a blatant lie. So next time you get on the Federal Register, can you trust what's in the Federal Register? I don't. The Ion Band to this day has not purchased 1 parcel of the 12 that are included in this Fee to Trust application. They do what they want, when they want, how they want. Law and regulation has no meaning to the DOI or the BIA or the NIGC. 12 years, it's a done deal, breaking ground in 6 months. Finally, in 2012, keep in mind that Henry Tompkins had reinstated the restored lands opinion in June of 2011. Larry Eckelhawk was the assistant secretary at that point in time. He resigned in April of 2012. But without taking any action on this Fee to Trust application. This application had been sitting there since 2006. Almost immediately, the acting assistant secretary, one Donald Labadur, a GS employee. Oh yeah, keep in mind that the assistant secretary is a presidential nominated, Senate confirmed position. Mr. Labrador is a GS employee. But within days, Mr. Labrador had issued a record of decision and approved this feed of trust application. He has absolutely no authority to do that. None. The record of decision was issued. They tell you have 30 days to file a lawsuit. That's an arbitrary number, just stuck in the regulation by the department. Turns out that based on a case that you may or may not have heard, one man in Michigan filed a lawsuit some years ago. His name is David Patchik. Casino a couple of miles down the road from his home. Well, they did everything they could to discourage Mr. Patchik, to get his case kicked out of court. One of the outcomes of this case is that, the 30-day, for APA challenges, that 30 days is 6 years. You have 6 years for an APA challenge, not 30 days. I would encourage you, if there are any feed of trust that occur around here, that you do file something within 30 days. But you could file it within 6 years if you so desired. We filed within 30 days, as did Amador County. One of the things that's supposed to accompany a record of decision is a document called an administrative record. This would be the record that Mr. Labrador, or whoever made this decision, would have reviewed prior to making the decision. This was in May of 2012. We filed our lawsuit. We filed the first amended complaint in September of 2012. No administrative record. December, no administrative record. January, no administrative record. Finally, in May of 2013, a year after the record of decision was issued, we finally received an administrative record. Now, Mr. Labrador had been on the job for about a month when he issued our record of decision. The administrative record in our case runs to over 22,000 pages. Oh, and it's not complete. It's pretty obvious if you look at our administrative record, the first part of it, the first 18,000 or so pages of documents, they're in chronological order. And then there's a period of, on the pages, there's some pages where we go back in time and they're not in chronological order. And then they go back to chronological order, and then at the end, you can tell that they've just added records arbitrarily to what was the original administrative record. I said the record was incomplete in many ways. In 2006, when Mr. Artman wrote his opinion, he referenced the federal court case out of the Federal District Court in Sacramento, and he specifically mentioned the 1992 order. Anybody want to take a guess as to what document? Now remember, that order specifically states that the ion band had never been recognized. Anybody want to guess what document wasn't in the 22,000 page administrative record? That order. The other thing that we did during these years is we filed a number of FOIAs. Freedom of Information Act. I just read an article in, I think the local news, and it was in the Wall Street Journal, about one of the reasons that all of the documents relating to Hillary's emails, the only reason that these documents are coming to fore is because people and organizations have requested the documents through FOIA. And that your request through FOIA is more powerful than a congressional request from a congressional committee. It's in the Wall Street Journal yesterday. We have a lot of power. I guess nobody ever told us that though, did they? We have a lot of things that we can do. We have filed some FOIAs. Much to our surprise, as soon as the administrative record was released, we had filed a FOIA when Mr. Artman had issued his lands opinion. And we wanted all the documents that were related to the lands opinion. So about a month or so after we got the administrative record, one of our members who had submitted this FOIA received a fairly large package in the mail. This was the response to the FOIA request that had been made 6 years before. Just 6 years. They finally got around to it. But guess what was in that particular package? The 1992 order. So we contacted our attorney, Ken Williams, and he said, I wonder if this record, if the court record still exists. So he went down to the Federal District Court in Sacramento. Sacramento is about 35 miles from where we live. And he inquired. He put in a request to pull the record for this court case, which was concluded in 1996. Much to our surprise, they said, well, we don't have it here. But it might be in the archives somewhere. So a few days later, Ken called me and he said, I got some bad news for you. He said, they've contacted the archives and these records have been destroyed. Well, we still have the order. But there is a God in heaven. Because a day or two later, Ken called me and said, oh, I just got a call from a different archives center, and they have the entire record of this court case. The entire record. 10 boxes. 10 boxes. So he and I went down to the reading room at the Federal District Court, and we went through those 10 boxes. There is no doubt that the ion band have never been recognized. They're not restored. They're not landless. And not only that, they're on a tribe. They're not a tribe. In 1996, when the court case ended, the BIA undertook to organize the ion band. Okay, you heard right. To organize the ion band. I guess before then they had been the unorganized ion band. This organization was finally completed in 2002. The Indians at Ione have been divided into two factions almost since they existed on the 40 acres. The deed to the 40 acres says the property is titled to, and it gives the names of 12 individuals and other members of the Ione band. This particular deed was submitted to the BIA to have the land taken into trust, and there must have been somebody that day who wanted to get fired because they said this deed is not acceptable. The trust no property in trust. The two factions, after the band was organized in 2002, both appealed the decision, what had taken place, to the IBIA, the Interior Board of Indian Appeals. Both factions who live on the 40 acres appealed the decision of the BIA. The IBIA investigated. And at the very end of this report, of some very telling language, the BIA, the regional office, did all they could to organize this band. This group of Indians who would, these are their words, not mine, who would have never organized on their own. This is a group of Indians. They've never been organized. They would never have organized. They are a group of individuals, two families. A tribe was created. No one who lived on the 40 acres from either of these two factions was included in the new tribal government. The new tribal government was composed of Indians from other rancherias, and primarily from Sacramento County. Included among this membership is the now regional director of the BIA office in Sacramento. This begins to explain a lot, doesn't it? When their application for fee to trust was being processed, guess who was in charge of the realty office in Sacramento? Her name is Amy Dutschke. She's now the regional director. She's a member of the Ion Band. A member. I love that. Aren't you glad you're members of the United States? Oh, I'm a citizen of the United States. I'm a member at Sam's Club, by the way. Fee to trust. There is no authority in the Constitution for fee to trust, as I read my Constitution. I would invite you, read your Constitution. There are two ways in the Constitution for the federal government to acquire land. One is through eminent domain, and the other is found at Article 1, 8.17. That's the section of the Constitution where Congress, with the permission of the states, was able to set aside 10 square miles for the seat of the federal government. That's Washington, D.C. And the remainder of that particular section of the Constitution says that they have the same authority in all the other places that they purchase with the permission of the state legislature for forts, naval yards, magazines, and other needful buildings. I would submit to you that that doesn't include acquiring land for Indians or any other U.S. citizen. It is not a done deal. Robert told me, he says, you've got people right now here who are claiming that they're going to buy fee land and deed it to the reservation. There's no authority for it. And I would encourage you, when that happens, comment, stand up, make sure your legislators know that they can't do it. It's not a done deal. They would like for it to be a done deal. They would like nothing better than for it to be a done deal. When we first started in Plymouth, people would come and ask me, can you guarantee that there's not going to be a casino here? And my response was always this: I can't guarantee you that there's not going to be a casino here, but I'll guarantee you this: if I sit down and I don't speak up, I guarantee you there'll be a casino here. Thank you.